So I want to kind of do the distinction between those two.
Mm-hmm.
So guardianship is the legal ability for you to make decisions for somebody regarding themselves.
Okay.
Like, let's say, mental health care decisions, physical health care decisions, that impacts them as a person, right? Conservatorship is related, but it is focused on financial decision making.
Okay.
So go and invest their money for them, withdraw money from the bank, deposit money from the bank, open up a bank account. All those things fall under the conservatorship tree, but we oftentimes kind of just pile them together because when you want to take care of somebody, you really need both. So put in simple terms, guardianship and conservatorship are court processes that you have to go through. When a loved one that you have, let's say they're sick, maybe they got in an accident and they're in a coma, or they have some sort of mental ailment like Alzheimer's and they're unable to take care of themselves, you need to sometimes go to court in order to get permission to act on their behalf since they're not able to do that themselves. I am talking about legal decisions, but also it can be the full gamut of decisions for a person. You know, you think about your daily life and what you have to do. You've got to go to the bank, you might have to go to the doctor, you might have to sign paperwork, you might have to do all this different stuff that requires, legal capacity. And what I mean by capacity is just the ability to responsibly make decisions. Yeah, good question. So you need to be at least 18 to be someone's guardian. Typically, people want someone a little bit older than that because if anyone knows an 18-year-old, they're really, not equipped, most of them, to make all those decisions at that time. But that's the minimum threshold. And as long as you are, an interested party, meaning that there are set by law a pecking order, if you will, of who can be a guardian. Now, the important part about doing an estate plan is, like, whether that be a will or powers of attorney, you can nominate a guardian who you'd want it to be in advance. So that's one of the the beneficial things. But if you don't, then the court gets to pick, and they kind of have laws in place of who they're defaultly going to pick. But at the end of the day, it's a judge's call. So, let's take your scenario. She would come in and say, my son, Martin, he's an adult and he has had an accident where he's mentally not able to take care of himself. And what we would require from her, just the first steps is, we need to see a doctor's note that basically says, yes, according to my professional medical opinion, the doctor says you cannot make decisions for yourself. That's step one. And then when she brings that in, we can then help her to get a court date and petition the court to get permission to act on your behalf. Now, some people might say, well, that's crazy, she's your mom. Or maybe if they're married, they say, that's my spouse. Can't I just do that without this process? And the surprising answer to a lot of people is no. Just because you're married or just because you have a blood relationship doesn't mean you can just go act for somebody. Spouse is usually first, and then if you don't have a spouse, if you've got kids or a parent or grandparents, and it kind of goes out from the family tree from there. And those are people who have priority, and that's where it can kind of get a little bit messy because, as you can tell, sometimes when there's a tragedy in the family, like an accident like this, emotions run high. And sometimes people, you might have different opinions as to how you should take care of somebody. So maybe you have a couple of siblings fighting over control for mom and dad. And now what is already kind of a complex process that can take many months is going to get drawn out even more if we have people arguing in court. So that other sibling might retain their own lawyer to be able to be present during the guardianship hearing at court when the judge is going to listen to you and say, Martine, why do you think you need to act for your mom, and what would you want me to do if you could have your way? That's what the judge is doing in the hearing. He's listening. And then the other party, your sibling, who's represented by a lawyer would say, "Judge, I don't agree with what Martine is doing. I think he's acting out of his own self-interest and not in the best interest of mom, maybe.
Okay.
And I would rather it go this way. I want control of mom."
Okay.
And then the judge has to make a judgment call because he's got two people who both have priority, and he's got to make a call. Maybe he makes the right one, maybe he makes the wrong one, right? Yes, that's a good question, and that's what we deal with every day, is what we're preaching with estate planning when we do our seminars at the library or people come into the office for a consultation. We're always saying there's a way to avoid this process completely of having to go to court, and that's by doing documents beforehand.